Some housekeeping items before we get started. The washrooms, if you need them, are through the double doors at the back, and make two rights when you go out, and you will find them in the hallway. Just a reminder that this event is being recorded and will be shared on Facebook and our municipal website for those who are not able to join us tonight, that they can still receive this information. And just a bit about how we got to where we are today. So back in September of 2021, staff brought forward to Council a draft property standards bylaw. And Council asked staff to take the bylaw out to the public for public consultation. And so over the past 6 months, we have been receiving comments from the public through My Manitouage, which is our public engagement website. And I have a package of 173 responses that we've received so far. But one of the things that we haven't been able to do is have an open house because of the COVID pandemic and the restrictions on gathering. So we really wanted to be able to have an opportunity for people to come in and learn more about the property standards bylaw rather than reading about it on our website. So this is an opportunity, and we really appreciate you taking the time to come out and learn more about the property standards bylaw. There are a couple of reasons why we've brought this forward. So we currently have a property standards bylaw. It was approved by Council in 1987, and it's known as the Maintenance and Occupancy Standards. And surprisingly, it's not a lot different than what we're proposing in the new and updated property standards bylaw. But one of the big differences is that in 2018, the province downloaded the requirement for municipalities to enforce the Residential Tenancies Act, and which creates a minimum standard of property standards that a tenant can expect. And so we have to include this in our new and updated bylaw. And that's probably one of the biggest reasons why we have to do this. We have a guest speaker with us tonight, Shane Turner, and Jolene will introduce him shortly. But we ask that you allow Shane to give us a presentation, and then we will open the floor for questions and answers. And we'll take questions for about an hour if there's enough questions to be had. But I will also pull questions from the 173 responses that we did receive, which maybe will help engage and create more questions. So we won't be stuck for things to talk about. We understand that a number of concerns were raised. I have them documented in the survey responses received so far. The important thing tonight is that we receive your feedback to help guide us to establish a bylaw that works for Manitouage. And we can only do that through the input from public. But we ask that that input be respectful, and any comments or questions that you have will help us create the document that works for Manitouage, but it needs to be done respectfully. So we understand that there are concerns, but we can talk respectfully about those. And with that, I'm going to turn it over to Jolene, who will introduce Shane.
Actually, Shane has his own introduction that he's going to provide to us. I'm just going to minimize this. You can hear us and see us okay, Shane?
Yep, everything's fine.
Okay, perfect. So the floor is yours.
Okay, well, thank you, Jolene. First of all, I just want to start by saying that, let me give you some background. I've been in bylaw enforcement for 35 years. I just recently retired. I've known Marcel for several years. We talk a lot about bylaw enforcement issues and that sort of stuff. So we thought that today would be a good time to give everybody a chance to first of all, get some information and then express your concerns so that we can talk about them. And if there's not an answer that if we don't have an answer tonight, we will endeavor to get back to you, and we can talk about how that gets posted, say on the municipal website. But the first thing I want to say is, in my experience, when new regulations or new things are introduced into a municipality, there are concerns. So your concerns are, your concerns are recognized, and I think it really is more about ensuring that you've got an opportunity to express your concerns and hear, in layman's terms, so to speak, what the regulations or the intent is about. And I think a large part of this tonight is going to talk about intent and how to, how bylaws get regulated. Every municipality has bylaws. So what I'm going to do now, I believe I have the opportunity to share a screen. So I am going to share this, and I'm going to go to the top now.
I'm just going to screen.
Is this visible on your screen?
Yes, it is.
Oh, okay. So again, what I'm going to suggest is that we only have a few slides. It shouldn't take very long to go through them, and then we can get into the meat and potatoes of the meeting, which is to talk about concerns and try to provide some answers to them. So some of this stuff is basic information. First of all, any municipality that wants to enact any type of bylaw has to have the authority to do so from the province. So the authority for municipalities to enact property standards bylaws contained in the building code, and it's in sections 15.1 to 15.8. Property standards bylaws are designed and intended to meet the needs of the municipality. They're not compulsive or mandatory, I should say, in that every municipality has to have one. Although the province, with some of the regulations they've brought in place for the last few years, are starting to push towards making sure that municipalities deal with property standards versus provincial regulations. So the primary purpose of the bylaw really is to protect the built environment and the existing housing stock. The Building Code the Building Code itself, which is enforced by building inspectors, applies to new construction and renovation work that requires a permit. But the maintenance of those buildings and of that property once they're constructed falls to the municipality under the property standards bylaw. And let's face it, let's be honest with ourselves that buildings don't last forever and they need maintenance. The vast majority, in my experience, the vast majority of people are great in maintaining their property. However, every once in a while, there's a need to deal with something that someone doesn't want to do. And that's really what we're focusing on here tonight, is talking about those minimal situations where someone should be doing something that they're unwilling to do. And the municipality has some tools to deal with those types of situations. So, as was already mentioned, Manitowoc has an existing bylaw. It was enacted in 1987, which is obviously quite some time ago. It was enacted under previous legislation. It was enacted under the Planning Act, and that, we're talking about something that's 30-some years old, and so it needs to be updated. And municipalities change, and the characteristics of municipalities change over time. And so the bylaw, at any given time, most municipal bylaws should be reviewed from time to time to ensure that they are updated in a way that reflects the nature of the municipality at the time. And Manitowoc 30-some years ago might be a little different than it is now. I'll be honest in saying that I know the area a little bit. I was born in Thunder Bay, but lived most of my life in southern Ontario. So I'm somewhat familiar because I travel a lot and do some training up in northern Ontario. So I'm familiar with the types of concerns that might come forward. although I can't guarantee that I'm familiar with every concern you have. But really, the important part of any municipal regulation is to ensure that it meets the nature of the municipality. So the other part that was also mentioned is that the province has mandated that municipalities have to provide protection for tenants that live in rental dwellings. And there's two ways to do that. The province used to do it themselves. If a municipality didn't have a property standards bylaw, then they would... Sorry, I think I'm allergic to my dog. The municipality typically would rely on the province to enforce regulations around rental dwellings. But that was, a few years ago, was downloaded to the municipalities, and there's a couple of ways that they can do it. They can do it through a property standards bylaw, or they can enforce the provincial standards that are available. Typically, it's preferable that the standards that apply to the municipality be enforced, as opposed to relying on a sort of a blanket coverage of a provincial regulation. So, the long and the short of this particular slide is to highlight the fact that every municipality in Ontario, including Manitowoc, has to have some form of property standards enforcement. And so the standards that are contained in the bylaw are determined by council, and it's based on the nature of the municipality. Obviously, a bylaw, I work for the cities of Mississauga, Kitchener, and Waterloo. So they're large municipalities, and I'll say that up front. Their standards are likely to be different than in smaller municipalities, or more, or less, I should say, less urban municipalities. But some of the examples of things that are covered by a property standards bylaw are, first of all, they're pretty basic. We're talking about situations like the structural capacity of a building. If a building is not, or a deck on a building, let's say, or a shed or something like that, is not capable of withstanding the loads that are placed on it, then it needs to be repaired. Water penetration. We all know water penetration is probably one of the single biggest issues that can eat away at a structure over time. Plumbing and electrical systems also have to be maintained. And in some cases, the plumbing and electrical might be covered by the building code for a building inspector to deal with, but not always. So the safeguard in this, under a property standards bylaw, is just to ensure that you've got some standards available when you need to enforce them. The other thing that the council has the opportunity to do when setting standards for a bylaw is that they can do two things that allow them to apply the bylaw to certain classes of buildings or geographic regions in an area. I've dealt with some municipalities, particularly in Northern Ontario, where the municipality itself, the geographic location, could be thousands of square kilometers, but the town is in the middle, and so they focus on just within, say, the town or whatever. So that has councils can determine what types of buildings and where the bylaw applies. So, for example, a property standards bylaw could apply only to the exterior of a building, and not the interior, except for the fact that we now know that the province has dictated that municipalities have to have a mechanism in place to deal with the interior dwellings if a tenant is having problems with their landlord. So we have to keep that in mind. The other thing to understand is that these standards only apply to existing building components that are in disrepair. So, for example, if you've got a building that was built, I'm going to say, I'll pick a number, 40 years ago or 50 years ago or maybe even more. If the building code didn't require something at that time, the property standards bylaw cannot make you retrofit. So in other words, if something exists, it just has to be in good repair. This is not about going back and saying, well, you know what, you don't have this, and you don't have this, or you don't have items A, B, and C. If those items were not required at the time the building was built, the intent is not for property standards bylaws to go back and do things like bring your building up to today's code. If the code when the building was built required otherwise. The other part of this with this slide is that the buildings or properties can be dealt with. So, for example, if you've got an unlawful junkyard or something that's existed for years, then the bylaw can apply to those situations if it's deemed to be necessary. But those are only in situations that are deemed to be of a safety concern, for example. Okay. In terms of the authority of officers, obviously officers need to have a level of authority, and Marcel's been doing bylaw enforcement for several years and understands his authority. But property standards officers do have the authority to go into a property to do an inspection. Quite frankly, with any type of regulation, whether you get pulled over for a speeding ticket or a seatbelt offense or any other type of regulation, if officers that are enforcing that regulation don't have a level of authority, there's no sense having the rules in place in the first place. So a property standards officer can go onto your property to inspect if necessary. But they have to do it at a reasonable time, which means that they have to go during daylight hours. They have to knock on the door and show their identification to anybody that might be on the property. If it's a vacant property, it's a little different, but if there's a house on the property or a business on the property, they have to knock on the door or approach anybody that might be on the property to tell them who they are and why they're there. The other part that is really important to understand is that officers do not have the ability to go inside of a person's home without their consent. When we talk about dwelling units, that could be a room in a lodging house, or it could be your home or an apartment or basement apartment or whatever it is. Officers need to get the consent of a person to enter their dwelling. So no officers will be barging through doors demanding to inspect the interior of dwelling units. So in terms of what happens, if a violation is found on a property after the officer receives a complaint and feels the need to go and do an inspection, if they find that there is a violation, the typical first process is that they would send an informal warning. I mean, it could be as simple as an email or a letter or a handwritten notice at the door saying, hey, there's a problem with the railing on your porch, or there's a problem with this particular, whatever the item is, and you need to repair it. And contact me and we can talk it through. If someone doesn't respond to an informal warning, and again, those warnings might just be a knock at the door. I mean, I think the other part of this to understand is officers have several tools in their toolbox. Anywhere from just knocking on the door and saying, hey, we need to get this done, sure, no problem, I have it done in a week, to having to issue a piece of paper that says, hey, I just want to put you on notice this needs to be done. But if the repairs aren't done, then the officer can issue a property standards order. And what that order does, it says, here's what needs to be done, here's the time frame to comply, and if you feel that this order is not fair, either you don't think that you need to do all the repairs that are indicated on the property standards order, or you need more time, you can appeal the order. So every order is appealable, and it goes to a property standards committee, And the committee will, sorry, I got a couple of typos, I apologize for that. But an appeal committee will review the appeal and provide a ruling. And you have a chance to attend that hearing and say, here's why I don't think I should have to comply with this order. So there's always an opportunity for you to, to discuss the issue and contest the order if you so choose. But however, whenever it comes to property standards or any type of bylaw enforcement, whether it's a parking ticket or a, littering or dumping complaints or noise complaints or dogs off leash or whatever it might be, whenever you've got a regulation that that applies, there has to be some mechanism to enforce it for those people that just decide they're not going to comply. That's the same with any law in Canada. So property standards bylaws are really no different than any other law in Canada when it comes to saying, there's something you need to comply with. If you don't comply, then there's going to be a mechanism. Under property standards bylaws, municipalities have two choices. They could lay a charge. They could issue a ticket that you could fight and defend yourself in provincial offences court, and the charge would be for failing to comply with an order. Or the municipality also has the authority, if they so choose, to go onto your property and do the repairs, and the costs get billed to the property owner. I don't want to sugarcoat this to say that there are sanctions. If you go through the process and you dispute it, or you choose not to dispute it, or whatever, what in the final outcome is, if the order is upheld, then there needs to be some mechanism to ensure that the work gets done. So that's the overview and it's high level. I appreciate that, and we can get into the questions and the answers in a moment. But the other part of the bylaw itself is how it gets enforced. And so council has the ability to establish enforcement policies that the talk of the bylaw will be administered to ensure that it's fair and it's equitable. So, for example, some things that staff could be directed to do is say, well, we're only going to react to complaints. We're not going to be proactive. I can tell you that most municipalities do not have the resources to be proactive and go knocking on doors and jumping fences. That's just the reality. I know that sometimes is a concern when people say, well, geez, now we've got officers have this level of authority. The truth is they've had that level of authority for years. They just don't, they don't enforce it because, on a random basis because municipal resources just don't allow it. And the other part of this is if nobody's complaining, why would you get into a situation if nobody's complaining? So for example, council can dictate that the response is reactive or proactive. Reactive is reacting to complaints. Proactive is you're going out there looking for problems. I don't suspect that's going to happen. I can't speak for the Township of Manitouwadge, but I know in talking with them over the last while, I know the intent is to have a tool to deal with problems that can't be fixed otherwise. The other thing that council can do is assign priority to complaints to say that a serious complaint like a porch that looks like it might be falling down takes priority over, say, a broken window or something like that, based on the nature of the complaint that's registered. At this point, this is my understanding. It's subject to anything that staff at Manitouwadge might want to comment on, but from what I understand, there's no new staff resources anticipated, so it's not like there's going to be an army of officers being hired to enforce this bylaw. Bylaws really are just tools to help municipalities deal with problems, those minimal situations where somebody needs that extra push. So what I believe is going to happen, again, this is all based on discussions, is that the complaints will continue to be on a complaint basis only. And that's pretty much how Manitouwadge operates. operates with the property standards bylaw now, that's not going to, that my understanding is that's not going to change. So the focus of property standards bylaws is not to just go out there and start randomly jumping fences or checking properties. The focus is to deal with issues that create safety concerns that the municipality shouldn't ignore. As well as, and this is sort of my summation here, is it's dealing with issues that need to be dealt with if no one else is willing to deal with them. And also to deal with those types of situations that the province has mandated that the municipality must deal with. So that's it. I apologize. It's kind of a brief, but it's a high-level overview. I think probably the most important part of this is for us to get to questions and answers. And again, if there's, the intent for tonight is to take away your feedback. The bylaw is not enforced yet. It's not gone to council or anything like that. So there's an opportunity now to take the feedback and react to it as we see fit. So I'm going to stop sharing the screen. And Jolene, will I turn it over back to you?
Sure. Should we start recording this? Where am I here? Did you get it back? I don't think so. Shane, I don't think we have our host back. I think you still have it. Oh, I found it. I reclaimed it. We're good.
Recording in progress.
Didn't mean to steal the show on you there, Jolene.
Oh, no, that's okay. I apologize. I forgot to hit record before I gave him post earlier, so we're going to try to capture what we can.
Okay, so we're going to enter the question and answer period now. For the participants who have joined us online, at the bottom of your screen you will see a chat feature, and you can type your question into the chat and we will receive it and ask your question, or you can unmute yourself and ask the question that way. For the participants in the room, we have a microphone if you're comfortable coming up to the microphone to ask your question, or you can ask it from your seat as long as you can speak loudly enough that we can all hear it. So just wondering if there's anyone who would like to be brave enough to ask the first question.
I will.
Sure.
About a year ago, I met with Mr. Demers, looking at the bylaws that he was proposing. And mostly I was interested whether or not I was going to shoot my rat in the ditch. He assured me it wouldn't happen. The problem I have with this whole system, and I mentioned this to Mr. Demers, I said, every day when you drive to work, you drive down Station Road, and you have to see a greenhouse being put up along Station Road. What meant to do was still in the building. And I said, but you've seen this every day, and you know it's not a legal thing to do according to bylaws. He said, we're complaint oriented. Well, my merciful God, you mean to tell me that this town is based on rats? I can get away with anything, but he can't. Like, that's absolute foolishness. If you've got bylaws, enforce them. Period. None of this damn, we're waiting for a complaint. That's foolishness.
Thank you for your comment. Do you have a question or a comment regarding the property standard bylaw itself?
Yes. Property standards, I had a I had an officer on my property the other day, and that's not going to happen anymore. I don't want you people around. He came there, I had somebody parked at the end of my driveway, he told him, you're only allowed 30 feet from the intersection. So the guy said, well, get your tape measure. Well, he didn't have one. Well, if you don't have a damn tape measure, so they based it off. And it turned out to be like 33 feet. But just making a nuisance. So, no, I don't want anything to do with this. You come on my property, anybody comes on my property, you come to the ward, I'll ask you to leave once. If you don't leave, I'll remove you.
Thank you for your comment.
Thank you.
Is there anyone else who has a question? Marianne?
How is this different than a couple years ago, 2019-15, the beautification was...
Keep Manitowoc attractive bylaw.
Yeah.
You're going to ask what's the difference between the two?
Correct, that's my question.
The Keep Attractive Manitowoc bylaw can only be enforced with either a Part 1 ticket, or a warning, Part 1 tickets, or we take you to court. You cannot go to the Property Standard Committee and put your reason forward why you shouldn't be doing something. The property standard is a little different. If we ask you to do something, then you say, no, I don't want to do it. So then you have the possibility then to go to the Property Standard Committee and then put your complaint forward, and then they can decide if, yes, you need to do it, and no, you don't need to do it. If they decide no, that you still need to do it, then your next step is to appeal to a judge, and then goes to court, and then the judge will make they'll let you know that if you have to do it or not. Then if the judge says, ma'am, you have to do this, then therefore you have to follow the order and you have to do it. So you get all these steps that you can follow. The other one is that if you don't do it, we can either charge you or we can go and do the work and then you have to pay for it. So the property standard one, and also the property standard one's got more in it for the RTA, for us to enforce the Residency Tenancy Act. And that's for property that people are renting, to make sure that the tenant has his hot water, has his cold water, has his heat. That's the difference.
But there's an awful lot of overlap between the two, how will you decide, remember what standard, which bylaw is going to fall? Take, for instance, junk in your yard. It's in both. It's in beautification or the attractive, Keep Manitowoc Attractive Act, and it's also in the bylaw, this new bylaw that's being proposed. Who's decide which is which and whether or not you can appeal it?
Yeah, so to go back to the beginning, so when we did the property standard bylaw, when we did the Keep Manitowoc Attractive bylaw, at that time there was no provincial legislation to say that we had to do DRTA. So that was done first. And then after that, when we had to do a property standard bylaw, then we created a property standard bylaw with the RTA involved, and now we have two separate bylaws. You're right, they're similar, but they are different.
So does one override the other?
Not really, but the one that's got the most, the higher standard has to follow. So, for example, if you got a vehicle, an old junk in your backyard, and I could just give you an order to say, you know what, first of all, I say, can you get rid of that vehicle? And you say no. Then I could give you an order to remove it under either the property standard or the clear and clean bylaw. And penalty are basically the same if it's not removed.
Penalties are the same, but again, you're saying that under the attractive bylaw, it's do it or else, or do it or get fined. Under this new bylaw, it's saying you have steps to fight it, sorry, I'm struggling with the word, but you have...
You can appeal the decision.
Well, you have opportunities to
That's right. And that's put it there. If more serious, to me, if it's more serious, maybe you go through the property standard.
using your car example.
I would probably not use the property standard for one vehicle. But maybe use the property standard for multiple junks and stuff. Yeah.
So is this up to you? Is this your decision to which bylaw to put this under?
I would say maybe not my decision, but we'll look at it and we may discuss it in house and then go one way or the other.
All right, thank you.
Are there other questions? Omer?
Seems to be a little confused. I looked at the presentation, it seemed like it was more geared toward rental standards. Now, when I look at property standards, it's supposed to be in regards to rental standards, okay, but also dealing with building standards. In regards to building codes. You seem to be talking about yard maintenance. How's that all part of the standard? Well, because when you look at property standards, if you look at the definition, right, okay, the law was passed in 2019, the bylaw for the property. They say that the Building Code Act is for safety and general repairs, both exterior and interior of buildings and structures such as fences, retaining walls, and driveways. So are you looking for a property standard, or are you looking for a yard maintenance standard?
I think we'll...
I get confused because I hear people talking about different things, and that's not what I heard from the presentation.
Thanks, Omer. We'll turn it over to Shane to address the question.
Yeah, sorry. I'm not. I think I heard the answer. I think I heard the question. So I apologize if I have to, if I'm not right on point. But when it comes to property standards, the property standards bylaw can apply to land and to buildings. So I think you had mentioned the yards bylaw, and I apologize, I didn't quite hear the whole question. But if you've got municipalities often will deal with just the exterior of land itself, not the buildings, but land itself through a clean yards bylaw. But a property standards bylaw can do the same thing. But typically, and I think this is what Marcel said earlier, is that he would typically pick the opportunity that is probably the most appropriate for the situation. But when it comes to a building itself, like a structure, whether it's a garage, whether it's a shed, whether it's a house, an apartment building, whatever it is, that needs to that comes under the realm of the property standards bylaw. So there is a difference between the two. A clean yards bylaw only deals with land, the condition of the land, and all the stuff that might be on it. A property standards bylaw can do both, the yards and the building. And what it comes down to for officers like Marcel is having a tool in the toolbox to deal with what's the most appropriate approach. So a lot of it's going to focus on the seriousness of the issue and the safety concerns. So I hope that answers your question, and I apologize if I didn't hit it right on the nail, because I had a little bit of a problem in hearing all of your questions.
No, I understand where you're coming from now, yeah, but in the beginning I thought it was your presentation was more toward rental standards.
So with the rental standards, so the rental standards are something that the municipality has to deal with. They have to have a mechanism in place to deal with rental standards. So what we were saying is going through this exercise is updating those standards from 30 years ago to, to today's standards, while at the same time reviewing the existing bylaw. So a lot of the standards that are in the draft bylaw were in the old bylaw. They're carried forward. So, and again, please tell me if I'm not hitting the mark on your question. But the having a bylaw in place is important. So the key was to upgrade the standards for the rental dwellings, but also look at any regulations under the existing bylaw that no longer make sense and make it more efficient. So that's the first part. The second part, of course, is how it's enforced, which can be a council direction to staff. So again, sir, I apologize if I've missed a couple of components of your question. It's just because I didn't quite hear it all.
Is there another question? Shall I take one from my surveys? Okay.
I have one more.
Sure, go ahead.
No, okay, so you're going to incorporate the property standards to take in the chief building official's responsibility and the Clean Yard Act, right?
Not the chief building official, the bylaw enforcement officer.
Bylaw officer is not the chief building official.
Correct.
So how is he going to be able to do the proper standards of the building?
So there is a section, correct me if I'm wrong, Marcel, if you don't mind, there is a section in the bylaw that the chief building official will give direction to the municipal law enforcement officer if it comes to, say, under the building code for something structural or something that's unsafe, and they will collaborate together to enforce it. But it would be with the chief building official's action.
Yeah, Jolene's correct in that the focus or the person that's going to administer the bylaw is a property standards officer, which is the same as a bylaw enforcement officer. Marcel's had those duties for years, as did previous officers. But they can request request a specialist if they think there's a problem, but they need to get some expert advice. Marcel can rely on the chief building official to say, hey, is there a problem here or not? And if the chief building official says there's not a problem, then, then there's not a problem. So, in Marcel's situation or my situation over the years and all the officers I worked with over the years, if we're not sure about something, we're going to seek out some advice. So there's lots of tools, and I apologize for keep repeating it, but there's tools in the toolbox to say, let's make sure we get this right. Let's make sure that we treat the property owner fairly. So if there's any question of doubt or whatever, Marcel or any property standards officer has the ability to say, look, let's get a second opinion. Let's call in a plumber or electrician or a building inspector or an engineer, wherever to get to the point of needing to do that. It's not always about just one person making a decision. One person has the ability to administer the bylaw, and I'm using the term administer, not just necessarily enforce, because it's about making sure that it's administered properly and fairly. And so they rely on people that have advice on building code matters or electrical, plumbing, septic systems, whatever it is. And only those issues that need to be dealt with will be the focus. If it's not an issue, then the file gets closed.
Thanks.
Any more?
That's kind of
Okay. Is there anyone online who would like to ask a question? Okay. So one question that came up out of the many questions asked in the surveys we received, people shouldn't be permitted to live in private homes without water and heat. It isn't a safe situation and could easily affect the neighboring homes. How will the bylaw address this? Who would like to answer that?
So I apologize. I didn't quite hear all of the. My apologies. I didn't quite hear all of the question, but between Marcel and I, I'm sure we can address it.
People shouldn't be permitted to live in private homes without water and heat. It isn't a safe situation and could easily affect the neighboring homes. How will the bylaw address this?
So those would be situations where, if Marcel gets a call from somebody. I mean, the key part of this is there's a tool available now for people if they have a concern that they can report an issue. They report it to Marcel. Marcel has to go to the door and has to get permission, right, Marcel? I mean, you've got to get permission to enter. If that tenant or that person allows Marcel to enter, then he has the ability to say, these conditions are wrong and these need to be improved. We'd almost always request that if somebody's living in these conditions and it happens to be a property that they don't own, so for example, if it's rented or owned by somebody else, we'd almost always ask that they contact the landlord first. Give the landlord a chance to deal with the issue. If the landlord chooses not to deal with the issue, then that's where Marcel's level of authority comes into play. But yeah, I mean, certainly the description that you've talked about there certainly would be something that the property standards bylaw is designed to help somebody that's living in a situation that they shouldn't be living in.
But if they own the house and they refuse entry, there's not much you can do.
Well, that's true, right? I mean, if they're probably not going to call you in the first place.
That's right.
Right? But, I mean, the truth of the matter is, a lot of this relates to a level of tolerance, to be quite frank. If, like we talked about earlier, Marcel's not going to be, or any other officer that might be in Marcel's position, he's not going to be running around neighborhoods looking for problems. The resources that municipalities have now, and I speak from experience, are that the resources are pretty much focused on just responding to the concerns that are already expressed by the public. So if someone chooses not to call Marcel for an issue, whether it's an issue with their own living conditions or an issue with their neighbor, then that's their level of tolerance. If it's not a complaint, unless it's a safety issue. I mean, there's certain things that you just can't ignore, right? But for the most part, if it's a situation that comes to Marcel's attention, he's got a variety of tools to deal with it.
Sure, go ahead.
With respect to this comment that was written there,
Yes.
if I choose to live without water and heat, and the exterior of my building is not run down, what authority does the enforcement officer have if someone files a complaint that they think I'm living in poorer conditions than they are living? Like, what right does that have you to say I have to upgrade my living standards? I think that's what that question was asking, or not asking, but they're presenting it. And if I was living in that condition, then why is it your business? I have no water and heat.
So there's two things. If it was a rental unit, we can do lots. If it's private, there's not much you're going to do.
Oh, that's what I was getting at. Okay, I can understand the rental and the owner.
Yeah.
If the owner says, none of your business, go away, you have no authority to say, hook up water, hook up heat, right? It's my choice to live that way.
That's your choice, and they may end up calling the health unit and say, you know what, you want to check into this, and after that, that's the way it goes.
I I know what that question was asking, but if you're talking about the owner, it's nobody's business. Unless, of course, the building is run down and falling down.
And it's going to fall apart.
City by us.
And
Right.
it's a safety concern that the building is going to fall apart, that's different.
Yeah, okay.
And I think that,
There was really no authority, it's my place, my life.
yeah, and I think the question is a really good example of why it's important to have the updated bylaw to add in the Residential Tenancies Act information. Because at the moment, under our current bylaw, we can't act on behalf of tenants because it's not in the bylaw. And because that's being downloaded from the province onto municipalities, it really needs to be there. So if there is a tenant that's living in a home that has no heat and it has no water, this is an avenue for them to come to the township to make a complaint and have the issue rectified. Maria?
So should this not be a separate bylaw, the Tenancy Act management, as opposed to private citizens? It would make life much easier for both citizens and for myself.
We were told by the province it goes into our bylaw, or we enforce our bylaw proper standard, and we enforce the RTA provincially. And we, Residential Tenancy Act.
And the Residential Tenancies Act is a lot, it goes a lot more in depth into what we've presented in our draft property standards bylaw. And that is why we want to create a bylaw that is unique to Manitowoc and it works for our community. Because to enforce the Residential Tenancies Act, it is much more restrictive. And so we want to be able to create something that is more Manitowoc focused.
Correct me if I'm wrong, Shane. We had to do it, right? We had to do property standard, including the RTA.
Yes. The two choices are you either enforce your property standards bylaw or you enforce the provincial regulations. The problem with the provincial regulations, of course, is they're sort of a blanket that encompasses the entire province, as opposed to a property standards bylaw that can be custom fit to your municipality. But there is no choice. Municipalities have to provide protection for rental dwellings. If somebody chooses not to call, so be it. And obviously, owners that live in their own dwelling, that's never, how many times have you ever got a call about that, Marcel? That just never happens, right?
That's right.
But that protection has to be there for people that are living in situations where the landlord will not fix them.
That's right.
But again, why can't it be separate? I don't understand that part of it. Why can we not have two bylaws? One for tenants, one for homeowners.
I apologize. I didn't quite hear all that.
I'm just asking why we cannot have two separate bylaws then, one for tenants and one for standard homeowners.
Well, I guess you can, but why wouldn't you put the same standards in it? Why wouldn't you just create one document that has both standards in them?
Because one
That's
is
what this
must and one is shall. Or one is must, sorry, one is shall and the other is may. They're not, it's not required to paint your house, the inside of your house, or to keep the floor level, but in a tenancy situation it is. There are restrictions and regulations making sure that the inside of the house is painted and the floors are kept well and that sort of thing. They are very different animals.
Right. So the language you use, I mean, you're going to deal with the same situations, those same scenarios under two bylaws, or you can mold it into one and just ensure that you've got the right language. The phrase shall versus may can be in any, it can be in any bylaw, right? You can say that one section of the bylaw says, you may do this, or shall. The difference between may and shall is distinct. I get that. But you can use that language in the same bylaw And certainly that's something that we can take back and take a look at to ensure that that the provisions that relate to tenants complies with what the provincial standard is, and the other standards relate to maybe perhaps a more softer approach. So you can use this, as opposed to having two separate bylaws, you can have different standards within one bylaw.
So you have to sift through all of the bylaws to find out what pertains to your situation. So if somebody has an issue that they don't want to live with heat or water in their house, they have to look at it and differentiate between whether or not they live in a rent. I mean, whether or not the law pertains to a rental property or to a homeowner property. You have to figure that out on your own because it is not a separate document.
Well, but the document can be structured in such a way as to say that, so it's got different headings. So, for example, and again, first of all, I understand your concerns, and I think that the important part of this is to make sure that the public understands what's required or where they have to turn when situations come up. So, you could have a section in the property standards bylaw that's headed, or what the heading says, standards relating to residential dwellings. And most bylaws are structured in such a way as it's, here's the exterior of the building, here's the interior of the building. So again, you're making a good point. There could be two separate standards, or you could have all the standards in one, but you organize it in such a way as to say, if I'm just dealing with a rental residential dwelling, I'm going to page 12 of the bylaw. So I do believe that you can get at the same thing under one document.
For the record, I'd just like to see that happen, that they are very clearly differentiated within this new bylaw.
Do you have a copy of the...
Yeah, to be quite honest, that's a very good point. And that's something that, it's almost like you've got one bylaw with different sections relating to different things. And they're clearly, clearly headlined. That's a very good point. And it's not that difficult to do at all.
Do you have a copy of the draft bylaw with you? If you turn to page 26, you'll notice that Part 5 is specific to rented dwelling units.
Additional standards for rented dwelling units. That's additional. But earlier in the document, there is also it's scattered throughout. I thank you for finding that out. That does help, but there's still more work to be done.
Sure, we can definitely review it with that comment in mind, for sure.
Thank you.
Thanks, Maria. Any more questions? I've got some more here. This one is, can the township tell a homeowner at what temperature they should keep their home?
I'm sorry for laughing. If you live in my house, you better wear a sweater.
So I can tell you that the temperature in my house would be different if my wife is asking the question or if I'm asking the question. But the answer is that the municipality would only have the authority to regulate temperature if the tenant is not getting the temperature that the landlord is supposed to regulate. If this is an owner-occupied unit, if you want to live in 14 degrees or 28 degrees like my mother does, that's your call. The minimum heat restriction is only for those people to protect those people that can't control the heat themselves, which is typically tenants. Nobody's going to care about what the conditions that an owner-occupied dwelling lives in.
the municipal property included in there?
At the moment, it is exempt from the bylaw. In the draft, this draft document, it does state that municipal properties are exempt. But definitely the feedback that we received is that the residents would like to see the municipality maintain its properties to the same level as what's presented in the bylaw.
Because the municipality is also a rent. Where do those properties stand?
Well, I just want to clarify, we don't rent the trailers, we rent the land.
That's right.
So,
Then, you're saying that, it encompasses the land.
right. And we'll try to keep it focused on the property standards, but there are rental agreements in place for those properties. So it is outlined what's acceptable there.
From the vacant lot. The trailer part as a whole, not the ones that you rent, the empty lot.
Right. We're working on that, Omar.
I'm just asking a question,
No.
because we included in the bylaw.
It's also there, and it's also into the Keep Manitowoc Clear bylaw. All it's got to do is start doing enforcement, if that's what you're going to.
You got to enforce yourself.
I see what you mean. Yes, I
There's
understand.
hydro and hydro boxes there, there's holes in the ground, there's like, tripping hazards everywhere, there's blocks,
I see.
the general public don't want through there. So where, as rental properties, where does that fall under that?
Another comment that was made is that the township can come into your house and make you renovate it. Is this true?
The short answer is no. They can only come to your property and make you fix something that needs to be fixed. So when you say renovate, I mean, that's sort of a broad term, right? Make you renovate the house. That's sort of a broad term. Basically, the way I would answer that is to say the municipality, if they see that there's a problem with the property that needs to be addressed from a safety concern, either a safety concern to a person, but also the integrity of the building, right? So, like water penetration, for example, if water penetration goes unchecked, we all know there's no argument. Water penetration will deteriorate a building over time. There's no argument on that. So it could be a safety issue, or it could be a structural issue that is either immediate or it's going to take time to deal with. So the answer to the question is, the municipality only has the authority to ask you to fix a problem that they deem to be either a safety issue or a structural issue.
Maybe in follow-up to that, Shane, the property standards officer cannot come into your home and make you paint a certain color?
No, absolutely not. That's one of the things that needs to be very clear. Property standards officers will not go inside of a house unless they're invited. And I can tell you, in the vast majority, and I've been doing this for 35 years, and Marcel many years as well, both of us can attest, we don't go into people's homes unless we're invited. And that is the only time we ever get invited into a home is when a landlord or when a tenant is having a problem with their landlord. We always ask first, have you talked to the landlord? Because it's not fair for an officer to go to a landlord and ask them to fix a problem that they weren't already aware of. I mean, landlords have rights too.
We'll check in with the folks online if there's anyone who would like to ask a question.
I was just typing one, but I'm a slow typer. Can I say it? Can I ask it out loud?
Yes, go ahead, Katie.
Okay, so Shane, you've touched on this already, but the majority of the questions and concerns that I'm reading online from residents is that there's going to be a lot of money required of them. They're concerned that the township will ask them to build a fence or paint their home or do some major renovations on the outside to make it look quote-unquote beautiful. I just thought maybe that you could touch on that to put them at ease.
Yeah. So this isn't about making a property look beautiful. It's about minimum standards. So you know what? I mean, if nobody cares about your house color, that's your right. But if there is a situation, and I'll give you an example of something, where even if it's your own home, but you've got an eaves trough that's falling off, and it's clear that the foundation is getting deteriorated from water, that needs to be fixed because water penetration is an issue. Nobody's going to care about the color of your house. Nobody's going to care about what's inside your house unless you as a tenant ask us to care. This is not about fixing things up to somebody's arbitrary standard. It's about making sure that, again, two things happen. There are minimum standards to make sure that everybody's safe. So, for example, if you've got a front porch or a deck on a porch upstairs or a railing on a porch upstairs that's rotted over time, somebody falls off that deck, that's a liability issue. So those are the types of safety concerns. The other part of it is the structural components. This is not about colors of paint, and it's not saying that your house needs to look exactly like your neighbor. It just needs to make sure that the structure and the integrity of the building is maintained, and that there are no safety issues for the people that might either come on the property or on the property themselves. So, again, a railing that's that shakes a foot, gives way a foot or so on a second-story balcony. Those are the types of things that should be addressed. But they're typically only going to be addressed if it comes to the attention of the officers. And I think that the important part of this is understanding that the officers are going to focus on priorities. They're not going to be jumping fences. They're not going to be knocking on doors. Unless they have to go to their property, but they're not just randomly going to be out there searching for problems. I mean, I've been in this business for 35 years, and going back to the mid-'80s. We didn't do it then, we don't do it now. Municipal resources are about focusing on the problems that come to our attention. I'm sure if Marcel were to drive by something that was really unsafe, he's not going to ignore it. But for the most part, this is about making sure that the building is maintained to the point where it doesn't get run down and have to be demolished. Right? There's a lot of situations where people will say, "Well, how did we get to this point? How does this guy get to demolish a house and therefore take away a home for somebody because he just ignored it?" Property Standards Bylaw allows issues to be addressed so that you maintain the structural integrity of existing buildings and keep people safe. I hope that helps.
I'll turn it back over to the floor for any other questions. Homeowner, I know you have some more.
If I could, I'm sorry, if I could just interject and make a comment that my experience, and I know this is it's an issue of trust. I get that, and I know that it's been a challenging couple of years, and I know it's been a challenging few years, but the last 2 years have been challenging, and I get that there is a level of challenges or perhaps even mistrust of government. I get that. think it's important to understand that the Township of Manitowoc has had a property standards bylaw in place since the 80s. My gut tells me, and you can take this for what it's worth, but my gut tells me that as time goes on, you're not going to see a big difference in how things happen now. They just got it's about increasing tools in the toolbox. That's a cliche I've used for years and years. Deal with the situation based on the circumstances. So there's a bylaw in place now. It needs to be updated. It's 30-some years old. It needs to be updated, and I can pretty much guarantee you there probably wasn't a lot of public input back in the 80s on municipal bylaws. Things have changed now, and for the better, absolutely. And so municipalities have the opportunity now to comment on, regulations that affect them.
Thanks, Shane. Just skimming through the comments, I think most of them have been addressed. The comments that we received were mostly around the concern residents had that a bylaw officer could enter their property unannounced or without any notice, without a warrant, and that's clearly been answered, and that's not the case. Concerns with the township telling residents what temperature their house has to be set at, that was addressed, and that's clearly not the case. Concerns from residents about the cleanliness or the paint color within the house, that has been addressed, and that's clearly not the case. So I hope that the information that was presented tonight and the question and answer has provided more information to the residents, more information to the participants about what the property standards bylaw is intended to do. And Shane talked earlier about intent. What is its intent? And I can reiterate that we are not hiring more staff to proactively look for violations with any of our bylaws. All of our bylaws are complaint driven. That is how we have operated and how we will continue to operate. And I think it was just a really great presentation, a great opportunity to have these questions, have the answers, and be able to share in a very respectful way, and I appreciate that so much from all of the participants. Maria has her hand up with another question.
Yeah, sorry. It sounds like you're wrapping up, and I want to have to make sure I ask this question. Very last page 38 or 39, page 39, talks about the Property Standards Committee, and I remember that being in the questionnaire as well. What is the makeup? I understand there's 3 positions, citizens at large. How will those citizens be chosen? And what is their role in maintaining bylaws or judging the bylaws? I hate the word judging, but adjudicating, let's say, on these bylaws.
Would you like to answer that?
Yeah, so I'll answer the second part of the question, and then I'll let staff talk about how they get appointed, because it's a council appointment. They're not employees. They're independent. The committee members have to be independent people, so they're not city staff. But anyway, so the ability, there's 4 things that a Property Standards Appeal Committee can do. They can confirm the order, which means that they say the order stands as is. Or they could cancel the order altogether. I think the term is actually called rescind in the legislation, but they can confirm the order so the order stands as is. They can cancel it completely. They can modify the order, and what that would mean is, let's say, for example, there's 4 items on the order, and they say, we only think that 3 things need to be done. They could cancel the 4th item. That's what's called modified. or they can extend the time for compliance with the order. Let's say the officer gives a month, and the person comes forward and says, I need more time. The committee can say, okay, how much time do you need? It becomes a negotiation and mediation process. So they can confirm it, they can cancel it, they can change items on the order, or they can extend the time for compliance. Those are the only 4 things that the committee can do. How the committee members get appointed, I would, they're typically a committee that's appointed by council or unless there's delegated authority at the municipality. So I'll let staff talk about that part.
Sure. So similar to our other committees of council, there is an application form. Part of the survey did ask if people were interested in being on the Property Standards Committee. And just to let you know, based on the 173 responses we've received to date, we received input from 23 people to state that they are interested in being on the committee. And that's a wonderful response. So when we put the call out for volunteers to be considered to be appointed to the Property Standards Committee, that will be done through a public process. Staff will receive the applications and present them to council. Council appoints the participants, the members of the committee.
It's not councillors, it's not city employees, it's not...
No,
Okay.
No.
it's citizens, yes. Yeah.
Correct.
And is there going to be training for these people? Or they just show up and all of a sudden?
Yeah. There will be
Well,
training.
there is there's training available for Property Standards Committee members. There is no minimum requirement that they have to be somebody, a contractor with building skills or a lawyer or anything like that. So there's no minimum skills. Basically what it comes down to is vetting the applications, and then once the committee is chosen and appointed by council, then they're given training as to what the procedure of a hearing is and what their powers are. But the powers are theirs to exercise. Staff can't influence their authority, but they're given training on the process. They're not given training on being an expert in buildings or building a plumber or electrician or whatever. That's, if those types of people apply, that's great. But it's not that's not the training. The training specifically relates to the legal authority to run a hearing and their legal authority to decide to make decisions based on what the building code allows.
I have a question on that, if I can.
Sure.
Go ahead.
If this committee, the bylaw officer goes to the committee and says, this needs to be done for the town, and then the committee says, doesn't agree with it, is there an appeal process for the town?
If the committee says no, it's no.
That's a big
Well,
responsibility.
Okay, sorry, I'm sorry, I didn't quite hear that. Is there a process? Marcel, was that the question?
Yeah, so if the appeal committee say that, they say, no, you don't have to do that work, he's asking if the town now can appeal for the person to do the work.
So yeah, the answer is yes. The ability to appeal a decision of the committee, to take it basically to a court, exists for both the property owner and the municipality. Doesn't happen very often, but yes. Any decision of an appeal committee can be appealed to the courts. So there's 2 levels of appeal. And those 2 levels of appeal are available to both the municipality and the property owner.
So you got 20 days on both sides to appeal to a judge then.
But I can tell, and again, I'm speaking from experience. I'm not trying to influence. All I can do is rely on my experience. That very few times does a decision of the appeal committee get appealed to the higher court. And the reason for that is the whole reason for the appeal committee is if it's done properly, it's like a negotiation, a mediation process that says, here's what I think is unjust. And the municipality says, well, here's what I think needs to be done. And sometimes it's a battle, don't get me wrong. But most of the time it provides an opportunity for the two sides to come together and say, here's the reason why I don't think I need to do 15 things, 5 things, whatever it is. I agree with items 1, 2, 3, and 4, but I don't think I should do 5. And it gives an opportunity for the officer to negotiate, and then oftentimes the appeal committee will then say, okay, well, you know what, if you guys have worked it out, so be it. But the key focus of the appeal is that a homeowner or property owner gets an opportunity to state their case.
Yes.
Okay, back to the committee. Is the committee based on residents only, or is there voting or non-voting staff or council representatives on the committee?
At this time, we've identified in the terms of reference that it would be citizens only, but the committee would need to be have a staff resource work with them.
So like a clerk or a chair?
Yes.
Okay.
Yeah. So a member of the committee would be the chair, and the membership would elect the chair. And then Marcel, as a staff person, would be a resource as well. And then through our regular reporting to council, council would be informed if there was an appeal and what the outcome of that was.
I have a question.
Yes.
So if you have these, there's a body of 3, this committee?
Was it 3 or 5? 3. Okay.
So you have a body of 3. They don't run around knocking the doors either.
No.
They're waiting for a complaint to come through the office of the bylaw enforcement people. The bylaw enforcement people would go to committee with this complaint?
No.
No.
No. Okay.
This is an appeals committee.
That was an appeal committee?
Yeah.
Okay.
So just to clarify, if there was a complaint, Marcel would investigate. If he laid an order and the homeowner disagreed, then the homeowner has a mechanism to appeal that order to the committee. And then the committee would make the decision.
Yeah, and I believe it's 20 days to appeal to the committee.
Question, Omar?
No, I was just wondering who's going to pay for the committee. Going to pay for the fines or what?
It's volunteer.
As with all our committees, yeah.
We may provide coffee.
Depends on how long the meeting is. Okay. Are there any other questions? It's getting close to 8 o'clock. We'll start to wrap up. Online, I'll check in to see if there's any questions from our participants. Seeing none. I'd like to thank you, Shane, for your time tonight. Your experience and wisdom have been very helpful to us, and we certainly appreciate that.
Well, wisdom and my name are not usually used in the same sentence, but thank you anyway.
Thanks a lot, Shane.
Okay, take care, folks.
Thank you.
Sorry, it looks like Katie might have a question.
No, I was just celebrating you. Thank you for coming.
No, I appreciate it. Thanks very much. Good luck, everyone. And Marcel, I'm hoping maybe we'll see you in June. We're hoping to do a training session up there, so hopefully see you in June.
Okay, with me.
Take care, buddy.
Thanks, bye-bye.
Bye now.
Thank you, Shane.
And thank you for everyone for coming
Recording
out
stopped.
tonight. And appreciate again your input and your willingness to learn more. Great. Have a great evening.
I don't think your microphone's wrong.
No, they are, but there's something happening. We had issues with them last night, too. I don't know what's happening. They're not connecting to the speakers.
Because I can hear the voices here, but they really hurt.
No, and that's why I kept going up and going to the back, because I was trying to see what's going on. Connected their... I was texting Chris. But thanks for letting us know. We'll hopefully have that fixed in.
Why did I grab them?
Yeah.
You want to give me your list? No. I feel I was picking on you. No, right. That's that I see what you were saying. Yeah, no, I just like, a lot of municipal properties, you pay home about taxes, and you gotta run down this.
Oh, no, well,
Every one of those things that have to do with they're shaking the whole other thing like that.
yeah, those are, see, that's the stuff.
Oh, yeah, yeah. Go ahead.
Well, it wasn't the old bylaw, but it wasn't none of that. Like, what do you? That's all the, no, I think the clean bylaw was like,